So in Chapter 2 for business law, we looked at courts and alternative dispute resolutions and sort of the in-depth of around those two topics. So for what we were first supposed to do was explain what jurisdiction actually is. So basically, jurisdiction is, does the court have the authority over a specific case? Do they have the authority to make decisions or decide on a specific action? Not every court is going to have authority over every single case. So basically, one way to describe it would be comparing it to power. Like, do they have the power to do so, to make that decision, whatnot? So there are 5 dimensions of jurisdiction. We were told to look at 2. So the 2 that we were supposed to look at were in personam and in rem. So basically, in personam is against the person. So if you want to take a person or even a business to court, because we were also taught in that in the eyes of the law, a business or a corporation has similar rights as a regular person. They are able to commit a crime just like a regular person can. So you can take a business or a corporation to court. So basically, if they do something to you for whatever that may be, you can take them to court, and it would be in personam. This is determined by geographical location. Basically, where the person or the business, where they are in. Next, we have in rem. This is basically over a dispute over property. So, for example, if you find like a diamond ring, and someone takes you to court over it, this is going to be in rem because you're deciding who that belongs to. So it's over property. This is also based off of geographical location of where that product was. So yeah, those are the 2 that we were supposed to look at. One's against a person or business. One is over property. So next we were to look at describe in detail the following concepts. So long arm statutes. So basically, courts will use long arm statutes for non-residents of a specific state when they are brought to court. So, for example, if in order for this to happen, you are going to need minimum sufficient contact. So basically, you need to have enough contact in order for long arm statutes to be used. I did a little bit of research. I looked up what different types of minimum sufficient contact would be. Resident of the state, in-state activity, owns property, voluntary submission, presence in the state, or registered in the state. So those are different types of minimum sufficient contact. Next, we were to look at venues. So when describing a venue, this is basically oh my god, I lost it. Yeah. So basically, it's the most appropriate geographical location for a trial to happen with a jury. So most appropriate doesn't mean best. That's what we were taught. Basically, a defendant can try to change the area of their venue in order to seek a fair trial, or in an attempt to have a fair trial. So I know in class you used the example of one of the crimes that happened in Scotts Bluff, because it's such a small town. Basically, the word got around very easily, and there was, rightfully so, deep hatred towards this guy who committed the crime. And because it was in Scotts Bluff, based off of geographical location, the court was in Scotts Bluff. So basically, he tried to seek an alternative venue to kind of have people have a jury who didn't already have this hatred against him, trying to get a fair trial, but the judge didn't let that happen. So next to look at, we have standing to sue. So this is basically, you must have a good reason to sue somebody if you are trying to do so. This reason must be legitimate. You must have proof, and if it comes to something like an injury, the injury must be legally recognized. This could be like a burn or a broken bone, something that's like legitimate and recognized legally. You can't sue somebody or take somebody to court for a reason that's not justifiable. You need to be able to justify why you're taking them to court. Lastly, we were to look at ADR. So basically, ADR stands for Alternative Dispute Resolution. This is something that's big in sports contracts. And basically, this is used because a lot of the time litigation can be expensive. It can take a really long time. Or even, I know we talked about before, I wrote it down here, companies may not want to take something to court if it involves trade secrets, for example. That's just an example, because the court is public. If you take it to court, people can see it. Trade secrets, you don't want people to know. So different things like that. But basically, ADRs are inexpensive. They give each party a little bit more, get them a little more involved, and a little more control over the process. So there are 3 different types of ADR. There are negotiation, mediation, and arbitration. So the first one is negotiation. This is the most informal out of the 3. This is settlement talks, sometimes without attorneys. You're trying to come together and reach a goal. Like I said, that's very informal. You're just working together, talking to the other party, trying to resolve the case. Next is mediation. Mediation is basically you're using a third party, a neutral third party. This third party would be called a mediator. He suggests ways in which the parties can resolve their disputes. This is a way that's a little more formal than negotiation, but still not crazy formal. Generally, with mediation, there's going to be more compromise. So this guy's going to the mediator's going to make a suggestion on the ways that they could go. You're going to have to compromise a little bit more. Next is arbitration, which is big. I'm big into baseball, so arbitration is big in baseball. This is the most formal of the 3. This is where they will use an arbitrator. And basically, he hears both sides and puts together a resolution for the parties. This resolution is called an award, and usually it's the final word on the case. I think there may be some exceptions to that. I'm not too sure, but usually when the arbitrator makes his decision, that's the final decision. Usually between a player and a team, when they go into arbitration. The player wants a higher salary than what the team's offering. They're going to go into arbitration. He's going to decide based off of the stats and different things like that, a whole bunch of other factors. He's going to take all that in, and he's going to make a decision, and that's the final word. That's what that player is going to sign for, whether he likes it or not, or whether the team likes it or not. So yeah, basically that's what we looked at for Chapter 2.